Welcome back to the leaflet. Nipun, thank you again for being with us. Can you take the audience through what we discussed in episode 1?
You see, it's a very interesting question. The CrPC, which is the old legislation, and the new provisions of BNSS, which is the new law, are almost near identical. So one of the laudable objectives that was their call to war, right, was that, look, we are doing away with the colonial heritage. Look, it's this Macaulay's brainchild is being cast aside finally after 160 years of this law coming into picture. All of that is farcical because even the scheme of chapterization is the same. CrPC had 37 chapters, BNSS has 39 chapters, even the placement of provisions is kept the same. Save and except only 10 new provisions which have been incorporated, the entire scheme of the legislation is near identical. So the question that I have to ask myself is, what was the need to bring these new laws? And why make such hula-boo about the colonial heritage, etc., when every single definition clause would have been the same? In fact, Macaulay would go to the extent of saying it's my adopted child.
That's bizarre. That's very bizarre. Right. I'll come to the next question. A bit more specific now, Nipun. What is the issue with the police remand provision? Will the provision transform India into a police state? I mean, that's something.
Well, I'll just explain and then I'll let the viewers be the judge of whether India is in fact going where it is going. Right. Let me take you to the regime as it existed before the new laws came into picture on police remand specifically. You see, when an FIR is registered, first thing that you would have seen with every news channel's telecasting on any high-stake matter is the accused was presented before the court and the court sent him to police custody or judicial remand, right? Now the law as it stood then under 167 CrPC, just to give you the context for the lawyers, a police remand is a remand where for the first 15 days of a person being presented before the court, the person is sent to the police custody, right? Where the police will try to elicit truth, they will interrogate and they will use all their mechanisms known to law in an ideal scenario, right? A person is thereafter produced again before the magistrate who will, upon expiry of the police remand, which cannot exceed a period of 15 days, will send that person to judicial custody, yani jail, right? So police custody is police lockup, judicial custody is jail, right? Now that 15-day period was the maximum that a police can take hold of an accused for the purpose of interrogation, etc. It may not always be 15 days. It could all be 2 days, 3 days, depending upon the severity of crime, nature of allegations, so on and so forth. Under the new law, there is a specific provision under 187, which has done away with that cap of 15 days.
Oh, so now you're saying they can be there for as long as the police wants?
They can be there for as long as the charge sheet is supposed to be filed. And the charge sheet is supposed to be filed where the offence is under 7 years within 60 days and where the offence is over 7 years within a period of 90 days. So that protection which was there in the earlier law, which there was by way of a proviso which said not exceeding 15 days in police custody, that proviso has been omitted altogether in this new law. So here the mischief is done by omitting a protection, a safeguard which was there in the old law and not there in the new law. So now let's look at the effect of it. The effect is that a police, after taking a person under custody, can keep the person in that custody and that cap of 15 days will not come in the way, which used to be an obstruction for the police. And let me also go a step further. This is even more heinous than, say, special legislations like NDPS, for example. In NDPS, that 90-day period is not, for the purpose of filing charge sheet, is extended to 180 days. How? Under 36A of the NDPS Act. But even in that provision, even under that act, the police could not keep a person beyond a period of 15 days in police custody. So what is essentially happening here is, while in special legislations like NDPS, you can keep somebody for 15 days maximum under police custody, but under BNSS, you can keep somebody for 60 days or alternatively 90 days because the protection has been removed. And very interestingly, BNSS does not say so in those words that the police shall have the right to keep somebody under police custody. But what they have done is the procedural safeguard which was there, that has been removed. And that has a direct bearing on somebody's right to life, right to personal dignity. Article 21, 22, all of them have been given a flyby as if it were.
So are we then looking at a situation where our constitutional benches are going to be flooded with violations of the constitution, of people's right to life and liberty?
Absolutely, because we all know what happens in police custodies. Police excesses have been taken judicial note of. So I'm not talking something which exists in vacuum. I'm talking about a scenario which is known to all. The judges have written judgments on note, right? We have a Sunil Batra, we have a DK Basu guidelines, which will be flouted left, right, and center now. Just to add to what I was saying, let's take the most draconian of provisions, Unlawful Activities Prevention Act, the terrorist law. There, the police can take custody of a person for a period of 30 days. But even there, the DSP has to present himself before the court, file an affidavit explaining why more custodial interrogation is required. In this case, there is no such provision. There is no responsibility cast on any police officer to seek custody beyond a specific period. What I'm saying is, unless and until the judiciary intervenes and says, sorry, the reading of this new provision will be similar to that, or read a proviso which was a procedural safeguard which said not exceeding 15 days in police custody. Either the judiciary adds word to the statute, which I don't think it can, or the provision will have to be struck down.
You just mentioned the Sunil Batra and DK Basu guidelines. Let's talk a bit about that and handcuffing. What do you have to say about that?
Well, handcuffing as it existed in 1980s.
And we talked about this in episode 1 as well.
We did. But there I made a fleeting reference. So here I'll dive deeper into handcuffing. So you had a 1980s scenario where many prison rules provided for specific instances of handcuffing. Who can you handcuff? For what duration can you handcuff? Whether you can handcuff a person who had multiple offenses registered against that person, or whether you can handcuff a person who is an under trial or a convict, right? Or in specific category of offenses, let's say terrorism or whatever, right? Those rules were subject matter of challenge before the Supreme Court way back in the 80s. And Justice V.R. Krishna Iyer, the indomitable self, struck down those rules as being unconstitutional on the ground that they infringed a person's personal liberty as well as dignity. Justice Iyer came down heavily on police officers who took pride in parading those people under cuffs and chains and said, you cannot put shackles on somebody's liberty because that person is only an accused. He is not yet convicted of an offense. Therefore, the presumption of innocence runs in his favor. In fact, he also borrowed lines from another very celebrated judgment called Francis Coralie Moulin. It says a person must have the protection of dignified life. And a dignified life does not mean an animalistic existence for a person to be chained in cuffs and brought to court. And therefore, the court said that handcuffing will be permissible in only exceptional situations on an affidavit being filed by a concerned police officer saying that this person is a walking threat. He has already abused the liberty granted further, and there are very stringent conditions of which apply, which I need not dwell into. But that was the law. So in short, the law that had existed until 1st July 2024 is that handcuffing is in exceptional circumstances. A person cannot just be paraded like that. Now what happens is the new law under section 43 subclause 3 says that handcuffing now will be done for a person where they give out certain offenses, list of offenses, but they also say or any habitual offender or repeat offender. Now here's the distinction. A term habitual offender is judicially recognized, right? Under the Habitual Offenders Act, etc., etc., where a person is convicted for more than one offense.
Right, exactly.
The expression repeat offender is not defined. Now, a repeat offender could mean a person against whom multiple FIRs are registered, and a person may not need be convicted for that. Let me give you a real life illustration. Suppose in today's world, matrimonial litigation is on the rise, and a disgruntled wife may decide to register 4 or 5 separate FIRs against all the in-laws in the family, right? Say, so there might be a 498A, there might be a domestic violence complaint, there might be a dowry prohibition act under 3 and 4 of that act, and there may be separate FIRs registered. Now, does that mean this includes a repeat offender? Because for all intents and purposes, the expression repeat offender would mean every father-in-law and mother-in-law who are now in their 80s would now be dragged on a handcuff if this law is allowed to operate, because the expression is not judicially recognized.
So we are also looking at a lot of interpretation that's going to happen now.
Absolutely. Since these terms are not judicially defined, it will open a Pandora's box, and this is why it becomes very important when you tinker with an established jurisprudence of 160 years through Indian courts defining every expression, and you change them all over in a span of an overnight overhaul, as if it were, then that has a very perilous effect on everybody, because there is a complete uncertainty. What does this expression mean? How does it apply to people? All those questions are just left in a lurch.
Wow, Nipun, that's been very insightful. I think the audience has got to know a lot today as well, including but not limited to me. We'll conclude episode 2 here, and looking forward to having you in episode 3.
Absolutely.
Please stay tuned in. See you in episode 3. Thank you.